The Honorable Court of Criminal Appeals is now in session.
Thank you and welcome to the Court of Criminal Appeals for the Middle Section of Tennessee. We are operating under unusual circumstances, but we're attempting to hear our cases in as expeditiously and normal fashion as we possibly can. And with the pandemic, and we would much prefer, of course, to be in our courtroom and have the cases heard and argued by the lawyers in person. But thanks to the efforts of the folks at the Administrative Office of the Courts, including Barbara Peck, and also our clerk's office, Jim Hivner, and his staff, we are able to continue hearing our cases, hearing oral arguments on these appeals. And we're grateful for all of their efforts during this difficult time. So, as most of you know, these criminal appeals are heard by a panel of 3 judges. And I have 2 excellent colleagues with me here this afternoon. I'm to my on the screen to my left, at least, is Judge Robert Holloway Jr. From Columbia, Tennessee. And on the other side of me is Judge Tim Easter from Williamson County, Tennessee. So we're honored to serve as the panel for these cases that are on the afternoon docket today. With regard to our procedure, it will be much the same as what we would employ in open court, and that is each side has 20 minutes to argue their case. We judges have, in fact, read your briefs, so we're familiar with the issues and we're familiar with the assertions in your briefs. We will, of course, we take these cases under advisement and closely examine the record, but we have not had the records examined at this point, but we will very soon after the arguments. From the appellant's side, if you wish to reserve any part of your 20 minutes for rebuttal argument, please let me know when you begin your argument, and I will help keep up with the time and let you know when it's time for you to end your first argument if you wish to save rebuttal time at that point. I don't believe I have any other preliminary matters, so Ms. Peoples, if you will call the first case, please.
State of Tennessee versus Frederick John Schmitz, Jr.
Mr. Baker, are you ready to proceed?
I'm ready, Judge.
All right. Do you wish to reserve some rebuttal time?
If you would, if I could have 3 minutes, maybe, Judge, that should be fine.
All right, certainly. Go right ahead when you're ready.
And Judge, you know, you've read the briefs. This is a very straightforward case. We've appealed 2 issues on this over 2 charges. Mr. Schmitz was charged and convicted of evading arrest in a motor vehicle, a Class C felony, and reckless driving. Our issue with these 2 particular counts, they're fact-driven, and I know that's the hardest standard to overcome, but in this particular case, the facts are pretty straightforward. Mr. Schmitz was driving in Hickman County on a motorcycle, according to the state, the testimony shows. There was an officer there checking a business for some other reason, just, you know, doing normal policing. Sees this motorcycle go by, clocks it at 71 miles an hour, and then he begins a pursuit, or however you want to characterize it. The short of the story is this. The officer, it's undisputed, he lost visual contact with his officer. It's late at night. The only other members of the public that was encountered that night was, from the testimony of the officer, he passed one car. It was never stated or testified to that Mr. Schmitz had passed another car or person on the road. This pursuit lasted about, the testimony was between 15 and 20 minutes. Once the pursuit started, the motorcycle's out of view, and then he catches up to Mr. Schmitz. And Mr. Schmitz, at that time, according to the testimony of the officer, there was some type of hand gesture, and what that was never defined. There was actually a limited instruction by the judge not to really draw any inferences from this hand gesture. But when the officer got back in visual contact with him, I'm jumping ahead to the actual, when they came together. The officer's testimony was, for that time he was doing about 30, but then he sped up to about 70 and then pulled in, I guess, to his home or a relative's home or something and pulled over. In the state, rests the conviction on that, well, essentially he sped up there and to go into this family's relatives where he pulled over and he was detained and ultimately arrested. Our issue specifically was, and we had asked Deputy Lindsay pretty straight questions about, what knowledge he had that you were behind him and so forth. And the testimony from Mr. Lindsay is, well, when he got Mr. Schmitz pulled over, he asked him, he said, well, Mr. Schmitz, he had been in a bar, got beat up. He thought that person was chasing him, and so forth. And I think that's undisputed. As a matter of fact, he testified that he did have marks on his nose and a knot on his head and so forth. So apparently some type of altercation had happened at this bar or something that he had got away from. And, Officer Lindsay then asked him, well, didn't you see my lights? And then there was kind of an ambiguous answer that really didn't tell me anything one way or another. But I had asked specifically Deputy Lindsay, I said, well, did he ever look in his mirrors? And, he could never answer me that anything from an objective standard that Mr. Schmitz knew that he was pursuing him, I guess, until later on in this chase or encounter, however you want to characterize it. But our issue is there was nothing in the record affirmatively saying that communication that's required by the statute, that there's a signal given by that officer that you're supposed to pull over and stop, is received by Mr. Schmitz. And then at that time, I'm assuming when he called up to Mr. Schmitz, I think the state is trying to make issue, well, he sped up, he must be evading. Well, we disagree. He sped up and then pulled over into a family's residence where he was ultimately detained. That's our first issue. We don't believe that the weight of the evidence in this particular case supports a conviction for evading. Number one, because that in that first part of the encounter, there's clearly nothing that would indicate that Mr. Schmitz was being pursued or that signal stop had been conveyed to Mr. Schmitz. And then furthermore, when he caught up and pulled into the driveway, he was clearly not evading because he pulled over. Now, the state takes issue, well, he sped up from 30 to 70 miles an hour and then pulled in and so forth. Well, I disagree. That's evading. Just the fact that I sped up to get to that destination doesn't typically tell me that I'm evading arrest or anything of that nature. So that's our first issue. The second issue we take or we assign error to is the conviction for reckless driving. The only testimony and the only evidence in the record was that Mr. Schmitz, at the time that he went by, was doing 71 miles an hour. Now, there was some additional testimony that, well, for brief periods, he might have got to 70. And furthermore, the officer testified he got over 100 miles an hour at certain points, trying to catch up to him. But reading the record, Deputy Lindsay said most of this chase was 30 miles an hour. He's not driving crazy or anything like that. There was no testimony that Mr. Schmitz had encountered any other cars, and he's on a motorcycle. It's late at night. And then we had asked Judge Water for a judgment of acquittal on this charge. And the judge said, well, I'm going to tender this to the jury because of the speeding. They can infer whether it's reckless driving. Well, that's not the standard, Judge. The standard, there is totally different elements on reckless driving. You had to put other people or property in danger. And I think the case law, by my read, is pretty clear cut. Speeding in of itself is not reckless driving because there's different elements to prove. So we've assigned error on that clearly there's nothing that indicates reckless driving in here from Mr. Schmitz. and it was error to overrule the judgment of acquittal or the motion for judgment of acquittal in this case, because the record is devoid of anything that establishes any other people were put in danger or property was put in danger. Specifically, we had asked Deputy Lindsay, well, was there any other cars on the road that night? And all he could testify, because he hadn't called up to him, he said, well, I passed one car, but there was nothing with Mr. Schmitz because he was out of sight at that time. So we don't even know whether Mr. Schmitz encountered the other car or not. So that's our two assignment of errors. It's pretty straightforward, Judge, and then I would yield the rest of my time to the state, other than my 3 minutes.
All right. Thank you, Mr. Baker. General Watkins, are you ready to proceed?
Yes, Your Honor. Good afternoon. Austin Watkins on behalf of the state of Tennessee. Filed a notice of appearance in this case to do the oral argument after my colleague who wrote the brief departed from the state attorney general's office. And the state's position is that this court should affirm both of these convictions because there was sufficient evidence to support both the evading arrest conviction and the reckless driving conviction. And so moving specifically to the evading arrest, Your Honor, if you look at the entire proof in this small record regarding, what under the Jackson standard, there was sufficient evidence for a rational jury to find beyond a reasonable doubt that Mr. Schmitz intentionally fled from Deputy Lindsay after receiving a signal to stop from both his blue lights and his sirens. And so, Your Honor's getting into the facts. Mr. Baker's done a really good job of kind of, laying those out for the court. Essentially, the proof was from primarily the deputy's testimony that here's what happened. And he says that he first heard the motorcycle coming toward him that Mr. Schmitz was on. He clocked it with his radar at 71 miles per hour in a 55 mile an hour zone. So he's going 16 miles per hour over the speed limit there. And he locks it in on his radar, and then it takes him a couple minutes to catch up with him, where he's going at times reaching about 100 miles per hour. As soon as the deputy catches up with Mr. Schmitz, he pulls off of the highway onto some back roads and slows down to about 30 miles per hour. And during the next 15 to 20 minutes before Mr. Schmitz comes to a stop, Deputy Lindsay has his blue lights on and his sirens activated. And then Deputy Lindsay does testify that during the course of this interaction, that Mr. Schmitz is making some gestures with his hand. And so after kind of going about 30 miles per hour and signaling to the officer something, he kind of unexpectedly, without warning, accelerates from about 30 to around 70 miles per hour again as he's going over a hill. And then Mr. Schmitz suddenly turns into his driveway and pulls the motorcycle behind a tree and then proceeds to walk straight into his house. And when Deputy Lindsay follows him into the driveway, Mr. Schmitz doesn't stop even after receiving verbal commands. And so, Your Honors, based on all that proof, a rational jury could have found that Mr. Schmitz knew he was being signaled to stop from Deputy Lindsay, and that he intentionally was attempting to elude Mr. Lindsay's attempts to effectuate a traffic stop. And so, Your Honors, there's a couple things on the signaling to stop issue. Deputy Lindsay testified that, one, there's really no reason to think that over the course of 15 or 20 minutes that Mr. Schmitz would not have seen the lights in his side mirrors of his motorcycle. And then that also, it being around midnight, that the blue lights are lighting up all of the objects on the side of the road, including, for example, trees and just anything that they would have passed. And so really a jury could have used its common sense to essentially say, you know what, like we think for this prolonged period of time and then slowing down to a lower speed, that you should have either seen the blue lights in your mirrors on the side of the road reflected, or that you would have heard the sirens going at 30 miles an hour. And that's something that a jury is entitled to make, Your Honors. And under the, Jackson standard, that's certainly enough for a jury to reasonably think, you know what, any other person in this situation would have known that they were being signaled to stop. And then second, Your Honors, the video of what happened when Deputy Lindsay was questioning Mr. Schmitz about why he didn't stop, he is kind of coy about it, and he kind of gives this story about thinking he was being pursued because he'd just been in a fight. And, Your Honors, the jury may have been able to infer from that he was kind of acknowledging that, oh, well, I knew I was being signaled to stop, but I was afraid of stopping because I thought the people who were pursuing me were the people who I had just gotten into this altercation with. So when you take all of that together, Your Honors, there's ample evidence here under this, favorable standard for the state that Mr. Schmitz knew that he was being signaled to stop. And then moving to kind of the second element here of whether or not there's enough for a jury to find that he was attempting to flee or elude the officer. Again, there's a couple of things here that the jury could reasonably rely on, which is this was a prolonged pursuit, essentially, that lasted from the deputy's testimony 15 to 20 minutes or so. Mr. Schmitz gets off of a highway, goes along on some back roads, and then at the last minute acts essentially, the deputy, I think, construed it as unreasonably when he caught the deputy off guard by accelerating from 30 to 70-ish miles an hour at the last minute, again, going over a hill as well, and then turning into a driveway, parking the motorcycle behind a tree, and then walking straight toward the home, and it's essentially ignoring the deputy's verbal commands to stop. So when you take all those things together, a jury can infer that Mr. Schmitz's intent was that he was hoping that kind of through this prolonged pursuit, changing speeds, alternating from 70 miles an hour, going down to 30, and then speeding up at the last minute to cut into his driveway, leaving his vehicle behind the tree, and then kind of trying to walk right in without, seeing what was going on around him, that's evidence that he was trying to elude this police officer. And so under this standard, that's enough for a rational jury to make a reasonable determination that this was evading arrest. Your Honors, if there are no questions specifically about the evading arrest charges or facts, I'll move then into this reckless driving conviction. And again, evaluating this, Mr. Schmitz is correct that essentially the precedent that there is on this issue is that it is possible for speed alone to support a conviction for willful and wanton conduct for reckless driving. However, this is not a situation, for example, in the Wilkinson's case that has been cited in the brief, where there were speeds reaching about 120 miles an hour. It's less than that. We've got about 16 miles per hour over the speed limit here. But there are a couple of additional facts that the state thinks that the jury could reasonably have kind of made its inference on, right? This is a place that they're presumably familiar with in their county there, discussion about specifically where on the highway it was. And that not only was, Mr. Schmitz going about 60 miles an hour over when the deputy first saw him, but part of, the danger then is he's going fast enough that the deputy does have to essentially kind of, potentially risk his own safety by speeding up over 100 miles an hour or so to try to catch him to initiate the traffic stop. There was testimony that the deputy saw at least one car on the road. I don't believe it was clear whether the deputy, felt confident that Mr. Schmitz had also passed that car, but he may have. I mean, the deputy is following him along the same, road here pretty quickly behind him, only a minute or two behind him. And so when you take that, it's around midnight, so it is dark, visibility is limited, and Mr. Schmitz is driving, a motorcycle. He's not driving a normal four-wheeled automobile that, I think a normal person, normal driver might construe as being, safer for, when we have some of these other cases where it's different when someone is traveling at a, higher rate of speed than normal in a four-wheel vehicle that's enclosed, where you have on the contrary, it's late at night and you've got someone who's on a motorcycle. And then when you take those things into account with this last kind of sudden intense acceleration at the end where he kind of, as he's cresting a hill and then cuts into a driveway, when you kind of construe all those things together, it's not just speed alone that this jury was presented with in this record. And what the law suggests is it's not just disregard for the safety of others, but even the disregard for the safety of the driver, of the offender himself, can also be considered to the basis of the risk of the disregard of safety can be one's own safety, is my understanding of the Wilkins case. And so, Your Honor, as you think, if you take all those together, that this is essentially just a jury determination that it can use those facts and go, you know what, based on our experience and our common sense as being, individuals who presumably have operated vehicles on, the roads in their county, that they felt that this was, exceeding that, kind of threshold of what would be not just negligence, but is getting into a willful kind of disregard for the safety of Mr. Schmitz himself and for the officer and anyone else who may have been on the streets that night. So that's essentially what we've got here, Your Honors. And so if there are any specific questions about it, the state feels confident that with these facts in this record, that a rational jury could have taken those facts and found beyond a reasonable doubt that there was evading arrest here and that there was reckless driving.
All right. Thank you, General. Rebuttal, Mr. Baker.
Judge, very briefly, and I'll go in reverse order that the general took them. Speaking of the reckless driving, specifically, and I think everybody can take judicial notice that an officer on a misdemeanor, if that pursuit would have been unsafe, he is supposed to terminate or not pursue. So it is inopposite and just irrational to say that, well, look, he's driving to the point where it's unsafe and it's reckless. But not only did I do that, I exceeded what he was driving by 30 miles an hour. And that's fact. That's in the record. That is just nothing but conjecture on an officer trying to make up an argument to stack charges on. And that's the fact of the matter here. You had speeding. It's clear cut. And as a lot of officers do, in my experience in the court system for years, year in, year out, is they like to put reckless driving on the speeding ticket. But the fact is the fact. The elements of reckless driving is not established here by anything more than conjecture or speculation. Because the fact is that officer drove 30 miles an hour over what Mr. Schmitz was driving. And if it was unsafe, we all know the officer's not supposed to pursue on a C misdemeanor traffic infraction. So I don't think that really has any merit other than we're just, trying to justify that charge at that point. And now going back to the evading, in the record, it's clear. I asked Lindsay, was there a lighted area? And he said, no, he didn't have any problem with him not stopping until he accelerated. Because when he asked, was there a lighted area? There was no lighted area for Mr. Schmitz to pull over and so forth. Deputy Lindsay was pretty frank. He had no problem until he accelerated there and turned into that driveway. So up until that point, by his own admission, there was really not an evading. His point was that brief period, well, I accelerated and then turned in. Well, does that justify an evading? I'd say it's exactly opposite, because it justifies the fact that he pulled in and pulled over. I mean, just the fact that he sped up to get to that place to pull over in and of itself is not evading. And that's, I just disagree with the facts as presented that, because it comes down to interpretation of facts. But when you look at them long and hard and objectively, there's not an evading here. If Mr. Schmitz was evading, he wouldn't have pulled in that driveway of his family members and put the bike over and waited for the officer or whatever he was doing there at that point. He would have kept going. He is on a motorcycle. He could have outrun that officer any day of the week had he chose. He knew the back roads. He's from Hickman County, and there's clearly not evading. At the end of the day, if you look at the facts, if you're evading and you want to evade, you wouldn't have stopped. I wouldn't have voluntarily pulled over, and Mr. Schmitz wouldn't have voluntarily pulled over. And that's the intent of the law, is somebody who is willfully, intentionally trying to evade a stop. And Mr. Schmitz was not. And I'd yield the rest of my time, Judge.
All right. Thank you, Mr. Baker and General. We appreciate the oral arguments and the well-written briefs. They'll assist us in making a decision. Also, we appreciate your willingness to participate in the oral arguments in this fashion on Zoom and being live streamed on the 10 Courts YouTube channel. So thank you for being here today, and we'll take the case under advisement and issue an opinion very soon. Thanks.
Thank you.
Madam Clerk, would you please adjourn court until the next case at 2 o'clock, I believe.
This court is now in recess.